All right, well, welcome to Invention-Con San Jose. Thanks for being here today. My name is Deepak Dasharia. I'm from the Office of Public Engagement of the U.S. Patent and Trademark Office. Today we do have a great program. We're going to talk about a little bit about patents, a little bit about trademarks, and we're going to have an expert panel of entrepreneurs that are all from the Bay Area to kind of share their experiences and their journeys on their way to becoming successful entrepreneurs and how they're paying it forward and helping the entrepreneurs of the next generation. With that, we're going to dive right into our introductory remarks from the Assistant Regional Director of the Silicon Valley Regional Office, Mr. Stephen Thozio.
There you go, sir. All right. Well, thank you so much for that, Deepak. And first of all, let me welcome all of you to the Silicon Valley Regional Office of the United States Patent and Trademark Office. As Deepak mentioned, I'm the Assistant Regional Director here for this office, and I think it's such a fitting location for today's topic of successful inventing. I mean, we're here at the heart of American innovation at the United States Patent and Trademark Office, right? This is one of only 4 regional offices that we have across the country. And I think here in Silicon Valley, this regional office represents somewhere around 1/3 of all of the patents filed in the United States and all of the trademarks registered across the United States. It is a truly innovative region of the country, and I think it's a great place to come together and learn about taking some of the successful next steps in starting a business, building your brand, and becoming a successful inventor. So with that, we'll hear from experts today from the U.S. Patent and Trademark Office on how to file your trademark registration and things to think about when building your brand, and also how to file your patent application and create that successful business around technology and around getting that patent on file. So with that, we have a number of presenters that are going to be ready to go. The presentation I'm going to go over is really just kind of a basic presentation on patents, so that you get a basic understanding of what patents are, what they can be used for, etc. And then my colleague Jolynn is actually going to come up and talk about a lot of the services and resources that we offer as well. Okay, so as I said, this is just going to be kind of a basic overview of the patent system. We do not provide legal advice at the U.S. Patent and Trademark Office. We can only provide you the information. If you do want legal advice, then you would need to consult the appropriate counsel, such as an attorney or registered practitioner. So I am going to do a little bit of a history of the patent system, what our role is, why inventions do matter. I'm also going to cover the different types of patents, etc., who can be an inventor, and I'm also going to talk a little bit about the anatomy of the patent, go over kind of the journey of the actual patent application process. I actually kind of talked to some of you beforehand about that. And then, like I said, my colleague Jolynn is going to talk about resources and assistance. So a lot of people don't actually know that our founding fathers of this country actually had the foresight to put intellectual property in our Constitution. It wasn't an amendment to the Constitution. It's in the original Constitution. And that is in Article 1, Section 8, Clause 8. And that says, the Congress shall have power to promote the progress of science and useful arts by securing for a limited time to authors and inventors the exclusive right to their respective writings and discoveries. So they had experienced patent systems before coming to the United States, and they understood the importance of intellectual property. Now, not just patents, that includes trademarks, copyrights, and as well. But they understood that, and they wanted to promote innovation. And patents are one way to promote innovation. And by promoting innovation, we can grow our economy and help to improve our society, etc. And we do that through the USPTO as well. And you'll be learning about trademarks a little bit later as well, and how they can also promote innovation. Now, by promoting innovation, we also provide some protective rights So for a limited time, you could actually receive exclusive rights if you were granted a patent. A lot of companies use patents to grow their companies, especially in this area, like venture capital type companies, et cetera. A lot of times they try to add patents to their portfolio to help them secure more venture capital. And they can also make new goods and services. And there could also be some promotional, personal growth, et cetera. All right, so let's talk about what a patent really is. So it is the right to exclude others from making, using, selling, offering for sale, or importing the claimed invention of your granted patent. Now, it is also for a limited term. So that means a U.S. patent is only valid in the United States. You can't try to use your U.S. patent in another country, and you can't, if you have a patent in another country, you can't try to use it in the United States. And there is also no such thing as a worldwide patent. These are the three types of patents that we offer: utility, design, and plant. A utility patent, I'll talk about a little bit more. That is the majority of the applications that we receive. There are design patents as well to ornamental designs, and then plants for asexually reproducible discoveries of plants, etc. So who can be inventor? Well, basically any person who contributed to the actual claimed invention of a patent application. So that could be an individual who actually did the inventing themselves, or it could be a group. We actually have a lot of applications out there that have groups of inventors. All right, so let's talk about the process a little bit. All right, so this is what the cover of a patent actually looks like. And there are a lot of parts to it. We see some highlighted here. There is an abstract that's on the, or the middle right, I guess, of the cover sheet you see there. That abstract is really a very, very brief summary of what that invention is. And then what you don't see on here is the written description. So the written description is actually the details of that actual invention. And you have to provide it in such detail so that somebody else, if they were to read your issued patent, that they could make and use it. And you might be like, wait, what? Why would I want somebody else to be able to understand how to make and use my invention? Well, that's actually part of the process. We're going to grant you those exclusive rights for a limited term, and then after that term has expired, then it's open to the public to make and use. And that's how we promote innovation, because then people can make improvements on what you've already disclosed. The drawings, again, you see a drawing on this cover sheet here. There could be multiple drawings on other pages in the patent. That's basically, what your invention actually looks like. And then the claims, that's kind of the real meat of the protection. So that actually defines the boundaries that you're seeking to protect. And that can be a little bit sticky for some people, but this is just one example of a claim. This is a very simplified claim for example purposes only. No, this is actually not a patented claim, but it is a very basic claim that it's a chair comprising a seat, a back supported and attached to that seat. It has some support arms attached to the seat and a back support, or to the back support as well, and then a base comprising a plurality of the legs attached to the seat. Well, we don't have very many different chairs in this room, but pretty much almost all the chairs in this room would meet that description. And I'm sure that you have chairs in your home, et cetera, that also would meet that description. But this is just a very general example of what a claim could look like for a patent. All right, so most of you are probably here because you probably already have an idea. And so now you need to decide, all right, should I even try to seek patent protection? Now, I did talk to some of you about this beforehand. We do have 4 categories of invention that we offer protection for utility patent applications. And as you see, they're listed up here. We've got a process, And that could be under a lot of different things. That could be steps of actually making a product. It could be steps of actually doing a process in, say, an app. That's another, we call those business method patents. So there's a lot of different things, like as far as like steps of actually doing something, algorithms, etc. A machine. So a machine is something that you can probably physically hold. One example of an area that I used to work with, clutches and transmissions. Those are like machines. A manufacturer, that is something that is made by a process. That could be this device right here. Maybe it was molded, etc. And then compositions of matter, think of like pharmaceuticals or hand creams, shampoos, etc. Those are all compositions of matter. Now, I actually told some of you this beforehand. I like to sum this up into two categories: a process and a product. Because the machine, the manufacturer, and the composition of matter are all basically products. They're physical objects. You can see them, touch them, etc. And then the process is more, like I said, the steps of doing something. Your idea also has to be novel and not obvious. Novel means it's new, no one else has ever made it before. And non-obvious means that if you made an improvement of something that already exists, somebody who understands that technology wouldn't have found that to be an obvious modification. Now, it's not a simple process of saying, oh, that would just be obvious. There is actually a legal process that we have to go through to make that determination. And that's what's going to happen during the examination of the application. The examiner is actually going to go through, they're going to do some searching, and they're actually going to determine whether your claimed invention that you've applied for is going to be novel or non-obvious. And they're going to be using what's called prior art. Now, this is a very unique term to the patent community. It's not talking about like art, like paintings, etc., that you would see in a museum. It's talking about publications. And that's anything that is publicly available in the public domain. It could be patents. It could be applications that have been published. It could also be journal articles. It could be any social media posts. So yes, if you post something on social media, that could be used as prior art, YouTube videos, etc. So one thing that I like to warn people about is publicly disclosing your invention too soon. We in the United States give a 12-month grace period that if you do publicly disclose something, that you can still file for a patent, file a patent application in the United States within 12 months of your public disclosure, and then we can't use that public disclosure against you. However, if you file outside of that 12-month window, that public disclosure could be used against you and prevent you from getting a patent. And this kind of leads into the next point about, okay, a lot of people get very excited about their invention and they want to share it with the world. And I mentioned social media, YouTube, etc. This is why I'm warning you about this, because you don't want to disclose too much that, again, that could be used against you. But there are ways that you could talk about your invention without fully disclosing things, etc. We want you to be able to champion your idea because, again, we're trying to promote innovation here. And a lot of times you might need to get some help, and so you might need to reach out to another company, manufacturer, etc., to kind of help with the process. One way that you can, potentially work with those companies is through non-disclosure agreements. Now, we do not handle them at the United States Patent and Trademark Office. You would need to work with an attorney to talk about a non-disclosure agreement. So, again, try to maintain confidentiality as best as you can prior to filing that application so that you're not going to stop yourself from being able to get a patent. Now drafting the application. So I did talk about this a little bit, the reason why you have to describe your invention in a lot of details so that somebody else can make and use your invention, that's what we call the quid pro quo. We're giving you an exclusive right to exclude others from making and using that claimed invention if you get a patent for a limited term. And in exchange for that, once that term expires, then the public can freely use that, and they can also make improvements on it. You also have to show that you had possession of that invention, and specifically the claimed invention. How do you do that? Basically in how you write things. As long as you describe it in enough detail, then it shows that you had possession of that invention. And I already talked about, somebody else has to be able to make and use your invention. We call that a person having ordinary skill in the art. And they have to be done without undue experimentation. Now, you don't have to necessarily handhold somebody through the process of how to make and use your invention. It has to be somebody who understands that technology. So you're not writing to somebody who doesn't understand the technology, you're writing to somebody who does understand that technology. And then you also have to at least have a best mode disclosed of that invention as well. Now, as far as the claims go, I kind of talked about this a little bit. These are the boundaries of the protection that you are trying to seek. Now, in that chair example that we had before, if that were issued as a patent, that would be a very problematic patent because those claims are so broad that, as I said, all the chairs in this room probably read on that claim, and chairs in your home, your offices, etc. And that could be a problem because then somebody starts coming after you for infringement if you start making a chair, that meets those criteria. And that's actually our role here at the USPTO, is to not allow so broad of claims that it does a disservice to the public. But you need to decide what those boundaries are. So you need to determine, okay, what protection am I trying to seek with the claims that I'm trying to get in this patent application? And that kind of takes some time to really understand. It is not something that is learned overnight. You have to kind of practice at it. And one of the best ways that we actually suggest that you learn about claims is actually looking at issued patents, because those have already gone through the process, and especially if you can find something that's actually related to what it is you've invented, then you're going to get help in looking at what somebody else has done. Now, don't copy their claims because they've already got patent protection on it, but you can at least use it as a guide. And then, of course, you're going to want to file that application with us as well. And once you've filed that application, this is kind of the process that it goes through. So on the left-hand side, you have the application being filed, and it does go through what we call a pre-examination process. And in that process, we're just checking to make sure that you did everything you were supposed to do. So you filed all of the paperwork you need to file, you completed all the forms, etc., and meeting all the requirements as well. Now, once it passes that pre-examination process, then it will actually be assigned to an examiner. Now, it does take a little while to get assigned to an examiner. We have a backlog of applications. Right now, we are averaging about 20 months before it gets assigned to an examiner, and then they can send out a first office action, which is determining whether or not you actually will get a patent or not at that time. And so if you actually look at that top circle there, so that's the examiner making decisions on your application. Once they've made those decisions, then they're going to send a communication to you called an office action. And that office action will describe whether or not you get a patent or not. And especially in the case where you are not eligible to get a patent at that time, they're going to explain why. Now, it is done in a very legal patentees type way. And so we definitely encourage you to talk to your examiner to help understand it if you're going to do this on your own. And then once that communication gets sent to you, you have a certain time period to reply. And you can then do amendments or arguments. Now, let me talk about that a little bit. So we're focusing mostly on the claims when we're talking about patent protection. And so if you had that really broad chair claim and the examiner's like, okay, well here, I found a chair that meets the limitations of this claim, and you're like, well, that's actually not my invention. I've described a lot more in my written description. Let me start pulling in some that don't really read on that piece of prior art that you found, examiner, and you can add those into your claims. And then basically you could submit that to the examiner, and then the examiner is going to reconsider whether or not your invention is patentable at that time. Another thing that you can do is you can actually argue. So if you don't feel that what the examiner has provided actually does prevent you from getting a patent, then you can actually present arguments to the examiner as well. Or you can actually do both. You can make some amendments, you can also present some arguments. Once all that has been submitted to us, it goes back to the same examiner who worked on your case to begin with, and then they're going to reconsider. It could come back to you saying, nope, we still don't think that you get a patent at this point, or the examiner could say, yep, all right, you've overcome the prior art that I have. I'm now going to issue you a patent. So you could go all the way to the right there, and you get what's called a notice of allowance. Another thing is you may decide, oh, this prior art really is good. I don't really have anything else in my written description that I could really bring into my claims, so I'm going to just let my case go abandoned. And that's kind of that top part there on the left, on the right-hand side. If you get into a situation with the examiner where you've gone back and forth, at least twice and maybe more, and you feel that the examiner's rejection is not appropriate and that you should get a patent, you can actually decide to appeal the examiner's decision as well. And then the appeal process, we have our Patent and Trademark Appeal Board, they're actually going to decide whether or not the examiner made an error in rejecting your claim or claims. And that is a panel of 3 judges that's going to make that decision. As I mentioned before, one of the things you should really do is stay involved in the process. You can request an interview with the examiner. The phone number for the examiner is on the last page of every single office action that they ever send out. So you can call them up, you can set up that interview. It can be telephonic, or you could actually request a video conference through Microsoft Teams right now. But do make sure that you do file that complete application, and that make sure you're disclosing everything, like I said before, so that somebody could make or use your invention. And again, as I said, you can call that, we would really like to emphasize the interview practice, because we have to do everything in written communication, but that interview, having that telephonic conversation, that can really make a difference between whether or not you get a patent. Now, before I go on to my colleague Jolene, I'd like to see what questions you have here in the room.
Okay, otherwise it's electric, right? Okay.
Hear the buzz. It's slightly immediate.
I have 2 questions. They might be related. So let's say you have the idea and you're in between the idea and the experimental data to show that the actual design or functionality of the idea that you have works. Is it a good idea to start with the disclosure or the claim, or should you wait?
Okay, so I just want to make sure people are okay. So I can't really tell you when you should file, but it is very common that people do a lot of process and development, experimentation before they decide to file.
Okay.
Because they want to make sure that they're going to protect things the best way possible. So it's really hard to say when the best time to file is, but as long as you can keep things, under wraps, confidential, that's better than, like the public disclosure that I mentioned before as well. And it's also very common with like large companies that do a lot of research and development that they are going to, they might be working on something for a couple of years before they decide to file for a patent.
Thank you. And the second part of that is related to let's say you file that and then you have the 12 months that kind of protect you before you file the actual patent. So I'm kind of in the patent kindergarten right now. So I wanted a little bit clarification on the process. You were talking about the patent process when it's assigned and reviewed and the backlog's 20 months. Is that at the end of the 12 months where that starts, or is it a whole new cycle?
Okay, so I think what you're referring to is provisional applications versus non-provisional applications. So we didn't really cover this in the presentation, but I'm happy to talk about it. So a provisional application is a tool that you can use to get an early filing date, and it gives you 12 months to work on your non-provisional application. But you only have 12 months. It is not extendable. Once you are ready to file that non-provisional application, as long as you file it within that 12 months of the provisional, you can now basically take that filing date of your provisional, that gives you an earlier filing date than your non-provisional. Basically, you're linking the two applications together. Anything that was disclosed in that provisional application anything that was disclosed in the provisional application that is in the non-provisional application will get the benefit of that earlier filing date. You can put new things in your non-provisional application that were not in your provisional. However, they're not going to get the benefit of that earlier filing date. They're only going to get the date of the filing of the non-provisional application. Now, provisional applications do not get examined at all. They actually are just filed with us. They are never published. And if you don't do anything like file a non-provisional application later on, then that case just goes abandoned.
Not too close, right?
Yeah,
Okay. You mentioned there's a term that once the patent's granted to somebody, there's only a term that you're able to use that for yourself, right? Is that a standard term for every invention, or does it depend on the type?
Oh, sure. So I think you're talking about patent term, is that correct?
Correct.
Okay. So for utility and plant patents, it is a 20-year term from the earliest filing date of that application. For design patents, it's 15 years from the issuance of the design patent.
One more question back here.
So once the term is over, is there a way to renew it?
No, there is no way to renew a patent term.
But your utility patent is 20 years from your, like say, you filed a provisional. Don't you get a little bit punished by potentially several years?
So to get the first part of that question for the online audience, it's talking about the delay that we have to examine applications because of the backlog. So we do have what's called patent term adjustments. So if there is a delay on our part for parts of the process, then we will actually provide what's called a patent term adjustment, which will actually add days to your patent term. And one of those is that first office action. We're actually supposed to get you a first office action within 14 months. But because of the backlog, it's more like 20 months. So that is one factor in determining a patent term adjustment.
Hi, you mentioned about the office action. So let's say you're not getting the patent, but you can argue or you can amendment, right? Let's say we are responsible within 30 days. So let's say if we did not get it, then what happens next? Do we have to reapply, or what's the process look like?
Okay, so let me just make sure I understand. So you're talking about you get an office action from an examiner and you have to reply, and you do reply. Okay, so once you reply, then now the examiner has to then review your reply and make a determination. You don't have to reapply or anything like that. It's that one application is going to continue through this whole process that I kind of showed here. Okay, so the question is, what happens if, like, the examiner still doesn't think that the claims are patentable? So that's where you can go through some different processes here. So you get essentially 2 chances with the filing of your application. So the first office action that we send out, we call that a non-final rejection, if the claims are being rejected. The second office action typically is what's called a final rejection. That basically closes that process, but you still have options. So one thing that's actually not listed on here is you could file what's called a request for continued examination. So if you've gotten that final rejection, you can still respond to that final. It's called an after final response. However, how you respond will determine whether or not the examiner actually enters it into the record or not. So if it doesn't get entered into the record, then your options are you can file that request for continued examination, which basically starts you over at the beginning with the examiner again. You can actually go to appeal, as I mentioned before, or there is also, you can decide to let your case go abandoned.
One more question here.
Thank you. I came across a patent application, a publication, recently from a competitor. It's, they're trying to patent a manufacturing process that yields a certain result. And they claim that the process yields a certain result. And I and a couple other people have found out that that product, they're either not using the process or the process doesn't work. My patent attorney told me that it doesn't matter if the process actually works or not. They could get a patent on it.
I guess I'm not, was there,
So what's the question?
is there a question behind that? I'm just trying to understand.
If I know that they're either not using the process and they're advertising that their product, that they are using the process and they're not, or I know that the process doesn't work like they claim, is that valuable information?
So there is what we call a utility requirement for our utility patent applications, which means that the invention has to have some sort of utility. Now, does that mean it has to have lots of utility? No, it just has to have at least one utility. So we do, like as examiners, so we hire engineers and scientists, and that is one of the evaluations that they actually do, is to make sure that the process is actually possible. And so they actually do go through that. And we do send out rejections if something is not possible, for example. So, for example, you probably have heard of cold fusion. Well, as we know, cold fusion does not exist on this planet. It does exist in our sun, but not on this planet. Or fusion, I should say, exists on the sun, but it's not cold fusion. But people are trying to replicate that here on this planet, but it's still not possible at this point. And so there are people who are trying to apply for patent protection on cold fusion, but we do deny that. As far as what information you have, we do offer third-party submissions that can be submitted in an application. There are time limits on when that third-party submission would have to be submitted to us. But if you go to our website and just do a search for third-party submission, you can find information on that. He's coming.
Okay, if I've received a patent on a product that I designed, and then I come up with some improvements to that product, but the patent is still live, is there a way to patent those improvements, or will I get rejected based on my original patent?
So it depends on the timing. You could try to apply for an application after you've received that patent and get maybe potentially get a patent on the improvements. There is that possibility. The other scenario is something that we see a little bit more common, because it does take a while to get through this patent application process, is improvements are being made while that application is still pending, and then people decide to file what's called a continuation or a divisional application, which is tied to that original application, and therefore, basically, it can't really be used against you.
But if it's been patented, is there a chance of?
There is a chance, as long as that improvement meets those requirements that I talked about earlier, where it's novel and non-obvious. So.
Okay, thanks.
How long does a patent need to be abandoned for until you can't unabandon it? And does that time depend on if it was fee related or they didn't respond to an office action, et cetera?
Really good question. To be honest, I'm not aware of a timeline that a case could be abandoned before it could be revived. There is a process that one has to go through in order to revive an abandoned application. Depending on that process, there's petitions and sometimes fees involved. There's a lot of information on our website on how to revive an abandoned application. All right, well, thank you very much. And now I'd like to have Jolene Illy come up and talk about our resources.
How's everybody doing? That was a lot of information, huh? Resources we have at the USPTO. One of the resources we have is the regional office, like we're here now, San Jose, the West Coast regional offices. The headquarters is in Alexandria, Virginia, the shaded red area. We're right outside of Washington, D.C. That is also home to the Eastern Regional Outreach Office, which I found out today, people didn't know we have 4 more regional offices. The green is the Midwest Regional Office, with the regional office being in Detroit, Michigan. If we move over to the purple, we call that our Rocky Mountain Regional Office, and that office is located in Denver, Colorado. If you go down below, the regional office, we call that our Texas region, and of course the office is in Dallas. So those are our regional offices, and they're there to promote innovation. They're also there to help you connect with resources in your community, government resources. So you can always tap into your regional office. And also there is a public search facility there. Rob mentioned prior art. That's a way for you to search for prior art. And it is at the regional offices, and it also is at the PTRC's libraries, which we will talk about a little later. Also, you see additional resources. Is the Inventor Assistance Center, Patent Pro Bono Program, Law School Clinics, Patent and Trademark Resource Center. The Inventor's Assistance Center, I'm going to skip over because we're going to talk about that a little later. But let's talk about the Patent Pro Bono Program. The Patent Pro Bono Program is a program that can match volunteer attorneys and agents with under-resourced inventors, small businesses, and entrepreneurs. This is an independent operated regional program. So they have different criteria, but there are 3 main criteria. It is an income level. You have to have knowledge of the patent system. That can come from filing a prior provisional application or taking a certification course about patents. And the last one is invention. Knowing your invention, being able to describe your invention and how it works. Remember that we have the Patent Pro Bono Program. We also have the Law School Clinic Certification Program. And I remember talking to someone about this out front. The Law School Certification Program, the Law School Clinics, actually have students who can help you through the process of filing a patent application. Now, these students are intellectual property, and they can assist, and they are supervised by a faculty member. And this law school also is independently, the law school clinics are independent, so they each have their own criteria. For the patent pro bono and the law school pro bono services, we do have a list on our website, USPTO.gov, and USPTO.gov is going to be your best friend throughout this process. So remember that USPTO.gov, so you can find more about the Law School Clinics Certification Program and the Patent Pro Bono Program. And then we have the Patent and Trademark Resource Center, which we'll talk about a little later. One of the best things we have is our Pro Se Assistance Center. Our Pro Se Assistance Center is for what we call Pro Se's, is for individual filing a patent application without representation of an attorney or agent. Now you can contact the Pro Se Assistance Center either by telephone number or by email. Remember that the employees at the Pro Se Assistance Center, USPTO cannot give legal advice, but we can assist you through the process. So we can help you navigate through the system. So we are customer focused. The Pro Se Assistance Center, like I said, we can help you navigate through USPTO.gov. We can help you obtain forms and help you fill out forms. And let you know that this is for independent vendors and small businesses. But the best feature by the Pro Se Assistance Center is they have one-on-one appointments. So you can call or you can go online, which I will show you a little later, and set up a one-on-one appointment with an analyst or a patent examiner to discuss your particular concern for your particular case. So those one-on-one appointments are available. They're like 30 minutes, and you can go online and actually register for one of those appointments. Next, we have the Patent Ombudsman program. The Patent Ombudsman program is if you feel like your application is stuck in the pipeline. For example, someone mentioned, what if I get an office action and I respond to the office action? Did I get another office action and I respond? If you have questions about maybe your application is stuck there in the pipeline somewhere, you can call the Patent Ombudsman and they will help get your application back on track. The Patent Ombudsman is managed by program analysts, and it's also staffed by points of contact in other businesses and patents. That way they can help get your application back on track. Next, I mentioned the Vendors Assistance Center. Now, the Vendor Assistance Center is our unique center because this is staffed with former supervisory patent examiners, primary examiners, people that actually have worked in the patent office. So you can ask them policy and procedure questions. So if you're reading a rule and you're not quite sure about it, you can call the Inventors Assistance Center, and they can help you out and say, hey, does this apply to what I'm doing right now? So please take advantage of the Inventors Assistance Center. We have the Application Assistance Unit. Now, the Application Assistance Unit will help you with some of the formality reviews. Rob told you there's a process in the beginning where you go through the formality review. They actually would check your application to make sure you have all the particular papers and documents you need. And that includes your specification, your claims, your drawings, things of that nature. If you're missing anything from that, the Application Assistance Unit number will be on the bottom of the notice you will receive from the Patent Office. So if you do not understand a notice, feel free to call the Application Assistance Unit and they will walk you through. Patent Electronic Business Center. Now, most of the centers are open 8:30 to 5. Inventors Assistance Center is open 8:30 to 8. Our Patent Electronic System is our longest open contact center, which is 6 a.m. to midnight, to make sure that you can file your applications anywhere in the U.S. They stay open to 6 a.m. to midnight. 99% of our applications are filed electronically through our patent systems. So if you have any concerns about filing your patent applications electronically, say you're having problems uploading a form or downloading something or viewing your applications, any technical issues you have with your electronic filing, you can call the Patent Electronics Business Center. So you're viewing applications, technical problems, you're having problems with your account, you can call the Patent Electronic Business Center. And also, just to let you know, it's cheaper also to file electronically, and you cannot submit your application at a regional office. It either has to be filed electronically, mailed to our Alexandria home office, or dropped off physically at our Alexandria headquarters. Patent and Trademark Resource Center. We do have John Savacor here, right there. He's at the Patent Trademark Research Center right across the street. Now, the Patent Trademark Resource Centers are in academic, public, and state libraries, and they are designated to disseminate patent and trademark information. They are actually trained by Patent and Trademark Office. They come down for training. There was one not too long ago. So these are expert librarians that have been trained on patent and trademark forms. They know about the website. They know about public searching. They can help you search. So please notice that there are, from this map, you can see there are quite a few patent and trademark resource centers. Actually, there are 92 of them. So just remember that they're there in your area to help you out, fill out forms or whatever you need. They know patents and trademarks. And again, John is here. And if you have any questions, you can see John. Last thing we have is what I told you earlier, USPTO.gov is your best friend. Remember USPTO.gov? Bob was telling you about filing a utility application guide that will take you step by step to filling out your patent application. You can go to patent process and also patent search. So there is information to help you do patent search. There's inventor and entrepreneur resources and what we call pro se assistance and micro entity. Some of you might be aware of micro entity. If you meet a certain level of income, you could get an 80% discount for micro entity. It's 60% for small entity, and then there's your regular fee you can pay. So again, if you're concerned about those things, you can check it out online, or if you forget, Pro Se Assistance Center can help you. I'm just going to quickly show you a few things on the website because we have revamped our website to make it easier to maneuver. While we're doing this, is there any questions before we move on to the website?
Got one back here.
Hi, I understand that if you're over 65, you can apply for accelerated review. Is that correct?
We do have petitions, a petition for health and petition for age. So you can petition for health and age. In that case, in those cases, your cases will go in the pipeline sooner, which Bob was saying that there is a backlog of 20.4 months, I believe it is. If you petition for age or health and it's granted, it will go in that to the examiner quicker. It's expedited to examiner. Okay, let's go to, if you just put over patents, you're getting started, you do your application process and maintaining a patent. That's great, right? But once you click on it, if you click on patents, you actually get 6 buckets. Patent basics. I know this is a lot of information here, but if you go to patent basics, all the information you heard today about filing, searching, is in patent basics. And also, if you're not sure what type of patent you need, if it's a utility, if it's a patent, if it's a trademark, a copyright, we do have something called IP Identified that can help you determine your intellectual property protection that you should have. Applying for a patent application assistance, there's 6 buckets, but your best bucket is your independent inventor. The last bucket, let's see if I can get my cursor there. Independent inventor, file an application on your own. This file an application on your own will tell you about the patent pro bono program, about the pro se assistance program. It has your forms, it has your fees. It also has the law school clinic program and scam prevention. And Jason's going to talk a little bit about scam prevention after I finish it. But the best thing about it is also you can do the Control F and let me type the best feature appointments. There you go. You can schedule an appointment right here for your one-on-one with a patent examiner. Your 30 minutes, it can be telephone, It could be virtual, where you can have that conversation with the examiner. And if you forget everything we did today, everything whatsoever we did today, let me see if I can go back. I gotta lean into it. Okay. Well, it's not cooperating. Oh, there we go. Well, it's not corrupt. Maybe I'm moving too fast. Let's go back. If I forget everything, you just hit contact us on the right-hand side, and it take you straight to all the information you need. Contact us. Contact us will take you to all the contact centers, all the information you need, and you can just call us and we'll be there to help you.